Hey everyone, it's Mark, and today we're taking a look at a sovereign citizen in court for not having insurance and for not displaying his license plates properly. Let's roll the audio.
Kevin Lee Carver.
I'm here on that matter.
Okay.
I am one of the people of the Republic of Oregon.
Okay, Mr. Carver, we've got an improper display of your plates as well as failure to carry proof of insurance, and how would you like to plead?
I don't intend to plea. I intend to answer in the form of demur, such that I do not acquiesce quasi-jurisdiction, because that's an issue to be brought up in my pleadings and briefs with the court.
Okay, Oregon doesn't recognize demurs anymore, so please tell me if you're going to, your three choices are, excuse me sir, I'm not going to interrupt you, and I ask that you not interrupt me. You can plead guilty, not guilty, or no contest. Which would you like to do?
Did the officer make a legal determination that I was in fact operating a motor vehicle at the alleged time?
The officer made an allegation that you have done that. He has not proven it to the court yet. He has made that allegation.
Okay, was I in fact operating a motor vehicle at that time?
I would have no idea without a trial, without hearing the evidence.
Okay, because according to Title 18, United States Code, section...
Okay, Mr. Carver, I'm going to cut you off there. If you want to make an argument, then let's get this set for trial. This is an arraignment. Arraignment is solely for the purpose of determining how someone is going to plead. So if you want to make a legal or factual argument, we'll set that for trial, okay?
Okay, I would like a formal hearing and a trial by jury.
You don't get a trial by jury, but we will have a trial to meet in about a month. The reason you don't get a jury trial is because this is a non-criminal matter.
But it's, the controversy exceeds $20, and pursuant to the 7th Amendment, I have the right to a trial by jury.
And I would refer you to, if you have a kind of piece of paper, I'll give you the site.
I have my Constitution with me.
And I appreciate that. The case is State v. Benoit, which is, it was issued on June 5th, 2013. Supreme Court case number S060858, which establishes that not all violations get a jury trial. If they're criminal, if they're crime-based such that they were founded in a crime but then decriminalized such that at some point you get you get sentenced to jail time, then you still have the right to a jury. This case is not the case.
But does the court have jurisdiction? Can the court prove corpus electi?
First of all, if you really thought the court had no jurisdiction, you wouldn't have shown up in the first place. Second of all, a crime doesn't require a corpus delicti, also known as an injured party. There are victimless crimes.
Yes, I have jurisdiction.
Can you prove it?
Yes, I said so.
But can you prove it? Is there
Carver,
evidence of corpus delicti?
Mr. Carver, one of the things about this court is I do not need to prove that. If you want to raise that defense, I'll make my ruling at that time. If you disagree with mine, you can seek redress through the appellate courts to try to get that overturned. This is not the venue to argue jurisdictional issues.
Sir, did you take an oath to uphold the Constitution?
Yes, I did. So now I have set this for trial. I will give this to Sam and she'll notify.
Objection, I would like a trial by jury.
You're not going to get a trial by jury, sir, okay?
Is the court denying me my right to a trial by jury?
No, I'm not, because you do not have a right to a trial by jury. Okay? We're done here.
Now we're gonna listen to the trial. This should be interesting.
Okay, Mr. Carver, before I get the trial started and get you and the officer sworn in, I want to go over just some basic things. First of all, this is a trial. This is a proceeding. We all have our roles to do. Individually, you don't owe me any respect. Individually, I don't owe you any respect. Neither one of us has done anything to earn the other's respect. That being said, though, I have to respect you as a litigant in this court. That's the role you play, and you deserve respect for that. Likewise, I am the judge. I've been appointed. I am entitled to a certain amount of respect for that. So I just ask that we both respect one another in our roles there. I am certainly going to allow you to make your arguments that you want. I understand there are a number of constitutions. I will tell you that I have had the opportunity to review your letter to King City, so I know the constitutional arguments. I will tell you that more likely than not, you're not going to like my rulings, and that's so be it. Okay, there are avenues for you to proceed to appeal my rulings, and I would encourage you to do. I will tell you that I admire anyone who is willing to challenge the status quo. I think that is an admirable thing to do. I don't think it's done often enough these days. But there are ways that it has to be done. And much of the relief you are seeking is inapplicable to this court. But I'm certainly going to let you make that argument. If I rule against you, I just ask that you respect the fact that I'm listening to you and I'm making a ruling to what I believe is accurate. If a subsequent court determines that I'm wrong, okay, it wouldn't be the first time someone's found that I'm wrong. If they find that I'm right, so be it, and you may need to appeal that to a higher court. So there are procedures for doing that. Before we begin, do you have any basic questions?
No.
Okay. So if you please stand, I'm going to ask both of you to raise your right hand to be sworn.
I do so under duress.
Pardon me?
I do so under duress.
Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth on penalty of perjury?
I do.
Okay, thank you. So, Mr. Carver, the way the process goes is the officer gets to go first since he has the burden of proof.
Okay.
He puts on his case. At the conclusion of his testimony, you'll have the opportunity to question him. It's not an opportunity to argue with him, merely to ask him any questions to clarify his testimony.
Okay.
When you've done with that, if the officer doesn't have anything further, he essentially rests. At that point, it goes over to you to tell me, make any arguments, tell me your side of the story, give any factual statements as well as the legal arguments. When you've concluded, the officer will have the opportunity to ask you questions. Again, not to argue with you, merely to clarify any of your testimony. At the conclusion of that, I will issue my ruling. And again, if I don't know what the end result is going to be on the violation, I have suspicions on the constitutional arguments where I'm going to end up, but you and I are going to have at least a somewhat detailed conversation on those. If there are areas of the law that you are addressing today that were not previously raised in your letter, I may not be familiar with those, and I may not, and I'll try to rule them as best of my ability. I'm going to ask you today, are you recording this hearing?
I am.
Okay, and I want to let you know that under Oregon law, it is unlawful to record conversations if you do not get the person's consent.
But it's in a public area.
It doesn't matter. If you're having a conversation with someone, says, I'm going to wait, I'm fine with you recording it. But I just want to let you know that in the future, Oregon's got this really, I don't understand why. If I'm having a telephone conversation with you, I can record that telephone conversation without telling you I'm recording it. If we're having a face-to-face conversation, I have to tell you I'm recording it. I don't understand why they made that differentiation, but the legislature did, and I'm going to respect it. That being said, I just want to get on the record that you are recording this, and I'm fine with that. Okay, so I specifically waived. Officer, do you have any objection to it being recorded?
I have no objection.
Okay. And Dave, you're a spectator, so I don't. I'm at least advising you that this is being recorded. So anything you do say, I don't believe you're not going to be called as a witness. I don't think. I'm not aware of, but just understand that if you do chime in, that's being recorded. If you want to put it up here, of course, we can better. Yeah. Okay, officer, you get to go first.
Good afternoon, Your Honor. My name is Daniel Heisman. I'm a law enforcement officer employed by the City of King City since October 1997. On January 27th, year 2014, at approximately 11:17 a.m., I was on duty in uniform and operating a marked patrol car on routine patrol driving west on Southwest Fisher Road towards Southwest 136th Avenue. Southwest Fisher Road near 136th Avenue is a public roadway within the state of Oregon, City of King City. On the mentioned date and time, while driving on Fisher Road, I observed a white Mitsubishi van driving behind my patrol car, also westbound on Fisher Road. As I looked at the Mitsubishi van approximately 2 to 4 car lengths behind me, I did not see a registration plate displayed on the front of that vehicle. I conducted a traffic stop on the Mitsubishi van on Southwest 134th Terrace, near Southwest Macbeth Drive. I contacted the driver of the van and told him that I stopped him because there was no license plate displayed on the front of the vehicle and requested to see his driver's license. The driver presented an Oregon driver's license. I observed that driver's license is issued to Mr. Kevin Carver. And Mr. Carver is present today at this proceeding as a defendant. Mr. Carver told me that his front plate is displayed on the dashboard of the van and is visible through the windshield. At the time I was standing speaking with Mr. Carver at the driver's door, I could see that the plate was displayed on the dashboard. I told Mr. Carver that the front plate must be displayed in a manner that allows it to be easily read. I further advised Mr. Carver that I was not able to see and read the plate information as he followed my patrol car. During the stop, I did step in front of Carver's vehicle and stood approximately 15 feet away. I looked at the front of Carver's van and had difficulty clearly reading the information on the plate, including the registration tags affixed to the bottom of the plate. The plate on the dash of Carver's van is easily read if you stand, as I mentioned, next to the driver's door or within close proximity to the front of the vehicle. I recontacted Carver after making that observation and requested to see his proof of liability insurance. Mr. Carver presented me with a handwritten note on a small piece of paper that had obviously been torn off of a larger sheet. The handwritten information included the name of an insurance company and expiration date. I told Carver that I was unable to accept that as a valid proof of insurance, and I asked Mr. Carver if he had anything else and to offer his proof of insurance and allow him an opportunity to search for the document. Mr. Carver did check the interior of his vehicle console and his glove box. Then he told me he did not have a printer, and the handwritten note was all he could provide.
It sounds like to me this guy wasn't a sovereign citizen at the time of the traffic stop. If I had to guess, he watched YouTube videos after this stop and went down the sovereign citizen rabbit hole.
Consequently, I issued Mr. Carver citations for improper display of registration plates and failure to carry proof of insurance. Relevant conditions at the time of the violation were light traffic flow in a residential district. That's all I have, Your Honor.
Okay. Mr. Carver, do you have any questions of the officer?
Are you making a legal determination that I was in fact operating a motor vehicle?
Yes.
Do you know the definition of a motor vehicle?
If I'm permitted to go get a book, ORS book, yeah.
I have it right here.
Well, I would prefer to read it out of the ORS book.
Title 18 United States Code oversees that. And it says here, at every description of
Okay, Mr. Carver, again, I'm going to interrupt you because this is more of an argument. The question was, does he know what the definition is?
I'm just explaining it to him.
Well, but he's already said he's relying upon the Oregon state law as opposed to 18 USC Section 31.
Right, but
so if you want to say that that's more of a legal argument that you and I are going to have, but you ask the officer, does he know, is he familiar with that statute? And the answer is going to be no, he's not. On what do you base your determination? He based it upon Oregon law. So that's kind of resolves that. I'd rather save our conversation regarding the applicability of that statute for our conversation as opposed to asking the officer, because I think you got the answer to the officer. Okay?
All right.
And you're going to have the opportunity to raise that issue, but that's more of a legal argument. The purpose on your questioning is more on the factual aspects of this. And so the factual aspects, of course, would be, where was the license, whether or not the license plate was adequately displayed, whether or not you had provided adequate proof of insurance. Those are the factual issues. The legal issues are really for you and I rather than you and the officer.
Right. But the license plate, the insurance, all that only applies to motor vehicles. It doesn't apply to my private Mitsubishi.
Okay, so let's you and I have a conversation on that right now. You're referring to 18 USC Section 31?
Yep.
Okay, so that
Definition 6.
Sub 6 specifically says the term motor vehicle, and that's for purposes of that statute. And that chapter, the chapter covers certain specific crimes, specifically destruction of aircraft or aircraft facilities, destruction of motor vehicles and motor vehicle facilities. Talks about Section 34 is penalty when death occurs. Section 35 is imparting or conveying false information. 36 is drive-by shooting. 37 is violence in international airports. 38 is fraud involving aircraft or space vehicle parts in interstate or foreign commerce. 39A is aiming a laser pointer at an aircraft, and 40 is commercial motor vehicles required to stop for inspection. So none of those crimes have been alleged against you today.
Right, but I wasn't operating under commercial purposes.
Whether or not you were operating under commercial purposes is irrelevant. If you were driving on a public roadway, you need a driver's license. It's really that simple.
Right, but you haven't been charged with a crime under that chapter. Therefore, the definition of motor vehicle for purposes of that chapter is inapplicable today.
How so?
Because that definition in the statute, it specifically says, for purposes of this chapter, the following definitions apply. And that's when it defines what a motor vehicle is, for purposes of that chapter. And that's very common in statutes where it says, For this chapter, we mean this. Now, that doesn't mean for another chapter, motor vehicle may be defined differently. So Oregon law has defined a motor vehicle that covers your Mitsubishi.
But I still have the right to travel.
Oh, you certainly have a right to travel in a motor vehicle, provided that if you're operating on...
It's a basic right, and there's plenty of court cases, Supreme Court cases that prove that.
Well, and on the issue of whether or not 18 U.S.C. Section 31 sub 6 applies, I'm going to rule against you on that one, because I've reviewed that statute.
Whether or not it applies or not, I still have the right to travel in my private conveyance.
Well, and that is not within my purview at this time. That what's before me today is two violations, which is one is failure to carry proof of insurance, and the other one is improper display of tags, or essentially license. So whether or not, I can't give you an advisory ruling as to if you were cited for driving and we got into an issue of whether or not you did have a right to drive your vehicle on roads. That's not before me today, and I can't give you an advisory ruling on that. So I'm not going to address that. That's something that if it comes up again, it comes up again, and we'll address it at that time. But I'm kind of limited to the two violations have been asserted against you at this point. So I'm from a legal standpoint, I'm telling you that I find that Section 18 USC Section 30, or pardon me, 18 USC Section 31 sub 6, the definition of motor vehicle in that statute, which is part of the definition section, is not applicable today. Okay, and that's obviously you can appeal that, and I'd encourage you to do so. Okay, but for purposes of today, I'm determining that does not apply. So if you have any factual questions for the officer, you can certainly ask them. And I'd love to, actually I want to hear specifically, and as I said, we're going to get into the constitutional issues and the other issues, but what I really would like to get down to is resolving the factual issue first, which is specifically, did you have insurance, and did you have the license plate properly displayed? So I would request, I can't require you, but I'm going to request that you address those issues first, and then we can go through the laundry list of other issues.
But there's no jurisdiction anyways, because where's the contract and where's the injured party?
Okay. And there, I assume you're referring to...
You're saying that it's a civil action, so there's two things. Where's the contract that's involved, and also the injured party?
It's not a civil action. This is a violation, which is a non-criminal matter.
You told me at the arraignment that it was a civil action.
Okay, and the way I use civil action is to differentiate from criminal actions. In essence, in actuality, there are criminal violations, there are non-criminal violations, and then there's civil actions. This is really a non-criminal violation, and if I said civil, I misspoke, and I apologize for that.
Okay, but where's the court's proof of jurisdiction?
I think the judge should prove jurisdiction to him by holding him in contempt of court, because right now, he's just wasting the court's time.
He has established jurisdiction because you were within the city limits of the city.
But I wasn't driving, I was only traveling.
Oregon law references operation of the vehicle, and my understanding, according to the officer, you were operating the vehicle.
Operation, I think I have the legal definition in here of what the operation means. Because lawfully I was not operating. Don't seem to have it in here. I don't have the definition in here, but if the court will look at Black's Law Dictionary, it would explain the definition of an operation.
Black's Law Dictionary is just that, a dictionary. It's not a law book. Not to mention the one sovereign citizens refer to is outdated, and the modern one debunks their beliefs.
Okay, and what do you believe the definition of operation is?
Okay, so you have a driver and an operator. The driver is the one who is employed to conduct the coach or carriage in the act of commerce, and the operator is one who actually owns it, to my understanding.
Okay, and I will disagree with that. My analysis, my experience in almost 30 years of practicing law, is when you're dealing with private, and we're not talking about commercial vehicles here, we're talking about private vehicles. the operator is deemed the person who is physically operating the car. It doesn't need to be an owner. They don't need to own it if they're operating it. And I've had situations where a fairly common one the Court of Appeals has addressed at least once or twice is where someone has passed out behind the wheel. So they're parked off the side. I had this happen in one case, not with a client of mine, but an adverse party. The person had come back from a Christmas party, had been drunk, passed out, but the car was still running. The keys were in it, the car was running, the lights were on. He had passed out though, and under Oregon law, he was deemed to be still operating that since he was behind the wheel with the car on. So under Oregon, current Oregon law, operating is determined to be behind the wheel, actually physically using the car.
Looks like I'm going to have to appeal that one too.
Okay, and trust me, I seriously do encourage you not. I'm not trying to be snide. I'm not trying to be sarcastic. Again, I admire someone who's challenging the status quo. So I want you to challenge, because if I'm wrong, I want to know I'm wrong. Okay. So certainly appealing that would I encourage you to do so. So do you have anything? One of the reasons I want to have you get back to the factual questions with the officer is because he is ill, and I don't want to make him stand up any longer than he has to. We can certainly have continued legal discussions, but I'd like to allow him to at least rest without having to worry about answering questions any longer than he has to. So, do you have any factual questions for the officer?
Well, one thing that did arise was because I was following you, and I had told you that I had the right to observe officers in their duty, but you told me that you didn't consent and that you would write me a citation for that. Do you have the legal...
I did not make that statement.
I have it on recording.
Okay, why don't you play back the recording?
Do that.
But let me ask, before we do that, what's the relevance in that?
Because that's the original reason why he stopped me.
Okay.
Because I was...
I have testified that I stopped the Mitsubishi because it did not have a front plate display. That's the reason for the stop.
But you also said another thing that concerns me is the fact that you're following me. Why are you following me? I have it all on tape. I can play it back.
Gentlemen, it's and here's where I am on that. Whether or not the officer stopped you, had an ulterior motive for stopping you, is somewhat irrelevant here. That may be a basis for a tort claim notice. If you feel he was harassing you, if you feel he was retaliating against you, that is more of a civil claim. That doesn't address, that's not a basis. If he had a reasonable basis for stopping you, which according to his testimony was the failure to properly display the license in front, that's what's relevant. Whether or not he did it for, putting it one way, if he did the right thing for the wrong reason, there may be other avenues for you to pursue, but that's not going to be relevant for today's case. Okay?
All right. And then the other thing too, I had another question, I can't think of it now.
And we can certainly, if you want to address some of the legal issues, we can, as long as the officers, as long as you're able to make it.
Yeah.
Okay. If you and I want to address some of the constitutional or the other larger issues, we can do that and allow and if you remember your factual question, I'll let you ask the officer later on. Okay?
Right.
What other legal issues would you like to talk about?
Well, I have a couple of Supreme Court cases here that state the right to travel. The use of the highway for the purpose of travel and transportation is not a mere privilege, but a common fundamental right of which the public and individuals cannot rightfully be deprived. Chicago Motor Coach versus Chicago.
And what's the year in that?
It was 1920 something, like 23 or 30.
Is that it's a U.S. Supreme Court case?
Yeah, I have the site right here. It's 169NE221.
Okay. 169NE.
Yes.
What's the page number?
221.
Okay. I will tell you just based on that site, it's unlikely to be a Supreme Court case. That more likely came from the Northeast, one of the Northeast districts, or it's probably a state case from somewhere in the Northeast. U.S. Supreme Court cases usually have sites that either U.S. or S Court, or I'm trying to remember what the other
Supreme Court reports.
Yeah, well, SCT is Supreme Court reports, but NE is not indicative of a U.S. Supreme Court case.
Okay, yeah, to my understanding that was. Okay. See, I got this other one here. This one's Thompson v. Smith. It's 154 SE 579. The right of the citizen to travel upon the public highways and to transport his property thereon, either by carriage or by automobile, is not a mere privilege which a city may prohibit or permit at will, but a common law right which he has under the right to life, liberty, and the pursuit of happiness.
Okay, and once again, the SE, generally when you see a reference to SE or NE, they're referring to reporters that are published by the West Publishing Company. And what they do is they separate the country into various regions. They have Northeast, Southeast, Northwest is one of the big ones. They got one just for California. I don't recall, they have one for Southern, which is SO. So those, to the extent that those are from Southeast, those two cases from Southeast and Northeast, they are not binding upon Oregon courts.
Okay, Shapiro versus Thompson, this is 394 U.S. 618. The right to travel is a right so basic it doesn't need to be mentioned.
I think this sovereign citizen has no clue what he's citing or talking about. He's probably just seen other sovereign citizens do it, so he thinks if he does it, it will work and it will get him out of trouble.
Okay.
And then there's Murdoch versus Pennsylvania, 319 U.S. 105. I'm sorry. A state may not impose a charge for the enjoyment of a right granted by the federal Constitution.
Okay.
Shuttlesworth versus Birmingham, Alabama, 373 U.S. 262. If the state converts a right into a privilege, the citizen can ignore the license and fee and engage in the right with impunity.
Okay.
Marbury versus Madison. I don't have the citation on this
I've got
one.
Marbury. That's one of the old ones. I learned that back in law school.
Anything in conflict with the Constitution is repugnant and null and void of law.
Well, yeah. I mean, Marbury dealt with a number of different matters.
Right. It was a judicial issue, but that was one of the things brought up by John Marshall.
Mm-hmm.
And let's see. Kent v. Doles, 357 U.S. 116, 125. The right to travel is part of the liberty of which a citizen cannot be rightfully deprived without due process of law under the Fifth Amendment. Shackman v. Doles, 96 APP DC 287, 225 F2D 938 at 341 or 941. The right to travel is a well-established common right that does not owe its existence to the federal government.
In that case, is of the federal second district, which would not. We're in the 9th district, so that may have. It has no binding effect upon Oregon courts. And those ones, they're federal courts. Do you have any Oregon law?
I don't have any specific Oregon law, but the Kent v. Doles is a Supreme Court case, and so is Shapiro v. Thompson.
And I understand that, but there's also a difference, and the courts have looked at this as far as what the state's rights are versus the federal rights, and federal highways versus state highways. The opinion came out October 3rd, 2013, which addressed that issue. I will also tell you that the right to a jury trial, even in civil cases, is not an absolute right, and I was able to find 2 examples of where a jury trial is not allowed in a civil case. First of all, divorce cases. Divorces are by nature a civil lawsuit. There's no right to a jury trial under Oregon law. Small claims trials. Oregon law has said that any claim for under $750 is mandatory small claims, and there's no right to a jury trial in a small claims action. I'm not saying that's right or wrong, but that's the law that as I understand it, and that's what I'm bound by. Certainly, and that can be a basis for an appeal, and again, I encourage that. Another argument you raised referenced that I was acting as both judge and prosecutor. I want to make it clear that I'm not. I am merely the judge in this. The prosecutor is, in effect, the officer. He is...
Did he have proof of corpus delicti as their injured party?
At this point, he's just repeating himself. There doesn't need to be an injured party. What don't you understand about that?
Can you clarify your question, please?
The phrase corpus delicti is generally is
the
used
body
in
of the crime.
Physical object, which upon which the crime was committed. Again, this is not a crime, so therefore there is no...
But then what am I being punished for? If there's a fine imposed on me, then there has to be, he has to have a lawful claim. He can't just say, oh, I didn't like where your plate was, so now you owe me $300.
No, he's deemed, in his opinion, that you have violated Oregon statute in two different ways. He has made that allegation, and he's been empowered to cite you into court on that violation. Let me finish, okay? He then comes in, and the way our system works is you certainly have the right to refute his allegations, and that's why we're here today. The officer has the burden of proof by proving by preponderance of the evidence whether or not his statements are sufficient and are more likely than not accurate. You then, if he has done that, and he has at least established his burden, the burden then shifts over to you to prove that, in fact, you did have the license plate properly. Hold on, let me just finish and then we'll talk. The burden shifts to you to prove that you did have the license plate properly and adequately displayed, as well as you did have proof of insurance with you. If you're able to establish that, so one of two things happens. Either I can't decide who's right and who's wrong, you win, because he has not then established the burden of proof. If I find that more likely than not you're correct and he's wrong, you prevail. But that's kind of where I'm dealing. So the corpus delicti doesn't apply, and me acting as judge and prosecutor isn't accurate because I'm not acting as prosecutor. That's the officer is acting as prosecutor. He's presenting the case. I'm merely making the factual and legal determinations based upon the evidence that I hear today. Okay, so I want to address that. And we can certainly, if I can, if you don't mind, I'd like to jump on. You also referenced denial of due process under the Fifth Amendment. And again, that I'm going to tell you that applies to crimes. And under current Oregon law, this is not considered a crime. It is considered a non-criminal violation. And therefore, the Fifth Amendment wouldn't apply. Just seeing if I've got any other notes. Oh, there's also something you had referenced in, with me acting as judge and prosecutor, you referenced 18 U.S.C. Section 208. That applies to administrative hearings, and that essentially, actually it only applies to federal employees, and then it bars acts affecting a personal financial interest. Again, I'm not a federal employee, and I don't have a dog in this fight. I get paid whether I'm here for trial, or whether I get paid whether you plead, whether you fight this. It doesn't matter. I essentially really do have no dog in the fight. Then you reference lack of jurisdiction under 5 U.S.C. 556. That's the one that references administrative hearings and judicial proceedings after the opportunity for administrative hearings. So that's not an applicable statute. Okay? That's kind of just going through my notes in response. Do you have any, and then you talked about a bill of attainder.
Right.
And I'm finding that this is not a bill of attainder, because the definition of bill of attainder is essentially a legislative quasi-judicial act. It's an act of legislation which singles out a particular individual and punishes them without an opportunity for a hearing or a trial. And that's Marbury versus Madison, where they said, the legislature, you can't do that. That's a judicial function. And that is the determination of whether someone has violated a law comes before the jury. So a bill of attainder doesn't apply here, because in this case, the law has been set out that says this is what you need to do and this is what you can't do. And in this case, it specifically talks about a proper display of the front license plate, and it talks about requiring proof of insurance. They're not, and they set the potential fines, but they don't say, you know, the officer can't write you a ticket and you have to pay that right then and there. You have due process, you have the right to a trial, which is why we're here today. Okay? So on those issues, would you like to discuss them further?
Yeah, statutes don't apply to traveling. They only apply to drivers.
Okay, I'll disagree with you on that.
I wasn't driving. That's the thing. I was just simply traveling. I was just watching Hyson on his duty.
Okay.
If I was driving, then I would have been transporting goods or services for some kind of money form or property or some kind of exchange, which I wasn't doing.
You don't need to be driving for commerce to be considered a driver. You were sitting in the driver's seat and you were operating a motor vehicle on a public roadway when the officer pulled you over. Therefore, you were driving.
Okay. I understand your argument. I disagree with it, though. Okay, driving and operating are the distinction, as far as I'm concerned, is operating. You can be sitting in a car while it's idling and you're still operating that vehicle, but you're not driving it. In my opinion, you're driving it if the vehicle is actually moving. So that's how I define or differentiate between operating and driving. I am finding, as a matter of law in my court, that it doesn't need to be for commerce. It doesn't need to be. You don't need to own the vehicle. You don't need to be getting paid to transport anything. Okay.
Right, but I still have the right to travel in my private conveyance. No court can overrule that. It's a natural right that was given by my creator.
Okay, I will disagree with you on that on a couple different bases. You certainly have the right to travel. You can go from town to town, state to state, country to limitations as far as country to country, but certainly in the United States, you can travel town to town, state to state. There are limitations where you can go. For example, I can bar you from coming onto my property. The government can bar you from coming onto their property. So there are limitations there. As far as operating or driving a motor vehicle on public highways, there can be limitations, and there are. If Oregon law has deemed that driving on public roads is deemed a privilege, the right to travel may be unfettered or limited fettered, but maybe almost essentially an absolute right. The right to use public roadways is not an absolute right. That is a privilege granted by the state.
It's actually a right because the gasoline tax pays for the roads.
Well, they don't pay for all the roads, but yes, okay. Even accepting that argument, it's still processed through the government. And therefore, Oregon has deemed that the right to travel on public roads is not a right but a privilege, which is why they...
But the Supreme Court has ruled to the contrary.
I disagree with your analysis on that.
It's right here, Shapiro versus Thompson.
Okay, and sir, I'm just telling you, I'm respectfully disagreeing with your analysis of the case law, okay? That's why they have appeals. By the way, did you have an opportunity to remember what you wanted to ask the officer?
I didn't.
Okay. Do you have anything further you'd like to add? Let me just ask you, do you have insurance?
I'm not lawfully required to have, so.
Okay, and the reason I asked...
At the time I did, but
okay.
I'm just saying though.
The reason I asked that is King City, we generally have what's called a fix-it ticket, which is if you do not carry proof insurance with you, but you do in fact have insurance, and you bring in proof that you had insurance at the time, generally we reduce or essentially dismiss that ticket as kind of a courtesy to people. I want to let you know that. So if you have with you today proof that you had insurance at the time, I'm willing to write off that ticket or reduce it down to $25. But other than that, I'm going to have to rule on both violations. But I certainly want to give you the opportunity to tell me anything else.
I'll definitely appeal it.
Okay. And I would ask one favor of you. When you appeal it, if you would copy me, and I'll give you my personal business card. And again, I'm curious. If I find what you're doing to be intriguing, I'm not sure I would have the time or the inclination to fight this battle like you are, but it still interests me. And to the extent that I can learn more, I'm always open to learn more.
Yeah, definitely.
Okay, so it's a request, rather. It's certainly not. I can't order you, and I wouldn't order you that. Do you have anything else you'd like to add?
No, I think that's it.
Okay, officer, do you have anything further you'd like to add?
I do not, Your Honor.
Okay, based upon the facts and evidence and legal arguments introduced today, I'm going to find Mr. Carver guilty on both of these violations. Carbon paper.
I always love to see a sovereign citizen lose in court, and I like how the judge handled the trial. He let the sovereign citizen spew his nonsense before the judge ruled against him. The sovereign citizen can appeal it, but we all know the appeal will go absolutely nowhere. As always, I would like to give a big shout out and thank you to all of my channel members for your support. I really appreciate all of your support, and all of you are awesome. And that's gonna do it for this video. Thank you all for watching, and be sure to like, share, comment, and subscribe. And I'll see you next time.